Mr. Attorney General, this is an outrageous, unprecedented slush fund that you set up. Simple question, will individuals who assaulted Capitol Hill police officers be eligible for this fund?
Well, as it makes plain, anybody is
just let me know if they're eligible for the fund.
As was made plain yesterday, anybody in this country is eligible to apply if they believe they were a victim of weaponization.
Mr. Attorney General, let me ask you this. Are there going to be rules that say that if you've assaulted a Capitol Hill police officer or committed a violent crime, you will not be eligible? Why not make that a rule?
I expect that, because I'm not one of the commissioners setting up the rules, I expect that there will be rules.
You're appointing 4 of the 5 members, aren't you, Mr. Attorney General?
Pardon me?
You're appointing 4 of the 5 members.
I am appointing all 5 members.
You can certainly set up the rules. I would hope you would make a rule that anyone convicted of assaulting a police officer or a violent crime is simply not eligible. They should not apply.
Well,
let me ask you this, because you compared it to the Keepseagle case. But I think you know full well that in that case, the settlement agreement was approved by a federal judge, including the payments to people who were not originally parties to the lawsuit. No federal judge has approved this fund, have they, Mr. Attorney General?
No federal judge did approve this.
So that's a big difference between this case and the case that you compared it to.
No, it's not.
Did a judge sign off on this case?
No.
A judge did sign off on the other one.
Yes, but your question was whether it's a big difference. It's not.
Of course it is, because that allows for an independent person to look at it rather than the
There was no independence. There was no independence. There was a single commissioner. A judge signed off on it. A judge had nothing to do with deciding the money.
There was a judge who looked at it and signed off on it. So to compare that case to this one is incredibly deceptive. Let me ask you this about the Epstein case, because as we speak, many Epstein survivors are in New York. They're reading portions of the Epstein files about the abuse that they suffered. Otherwise, they might have been here with us today. At a House hearing, your predecessor refused to acknowledge the pain experienced by some of those victims when the administration improperly released their names and identifying information. So I want to know where you stand. I spoke to the representatives of some of the Epstein survivors yesterday. They are extremely frustrated that you keep calling for people to come forward with more evidence, but you have not met with them to hear their stories. So simple question. If I connect you with these survivors, will you meet with them?
Absolutely, and what you just said is false. I have met with them. I've met with many of the lawyers for the survivors of victims, as did Attorney General Bondi. So whoever told you that, unfortunately, gave you bad information.
Okay.
But I would encourage them to reach out to the Department of Justice, because like we do every single day, we absolutely care for victims, and we absolutely want to hear from them and their lawyers.
Well, I've been told directly from the representatives they've not had a chance, at least this group, to meet with you. So
did they represent that they asked?
So I'm glad to hear that.
Did they represent they asked for a meeting?
Can I ask you to commit that the Justice Department will not recommend a pardon for anyone named in the Epstein files?
Can you repeat that question? I'm sorry. I didn't hear what you said.
Can you commit that the Justice Department, you, the Acting Attorney General, will not recommend a pardon for people named in the Epstein files?
When you say people named, there's tens of thousands, hundreds of thousands of, quote, people named.
How about Ghislaine Maxwell? Can you commit that you will?
Yes, I can commit to that, of course.
Okay. Let me go back to this slush fund, because there's also an individual who, after being pardoned by the president, went on to molest 2 children. And that person actually tried to buy the silence of these children by saying that he would pay them some of the funds that he was hoping to get from your slush fund. Can you commit to making the rules so that that person is not eligible for a payout under this fund?
Well, you're obviously lying in your question, because there's no way that this person committed to that. The slush fund, as you call it, which is not, didn't exist.
I'm certainly
but
not
I can commit.
Mr. Attorney General, don't ever do that again. I am reporting
what again?
What he said. He said on the expectation that he hoped to get some of the funds from a payout. He's been hearing
you said from the slush fund, Senator, and that didn't exist when he said that.
This is the fund that the president and all of you have been telegraphing all along that you're going to use to help the president's friends.
Can you point to a
Mr.
single
Attorney General, I
telegraph
have a
I
last
made?
question.
What telegraph did I
I
make?
have a last question for
Okay.
you. Do you know that it is a criminal offense to lie to Congress?
I am very well aware of that.
I'm glad to hear that. Thank you.
Senator Van Hollen did not let up. Instead, he intensified his questioning, turning what could have been a standard legislative debate into a high-stakes cross-examination. This follow-up exchange over the Department of Justice's newly minted $1.8 billion anti-weaponization fund and the unresolved handling of the Jeffrey Epstein investigation exposed a raw, escalating clash over institutional boundaries, legal precedents, and personal credibility. To understand why Van Hollen pressed so hard on the mechanics of the fund, you have to look at the legal shield acting Attorney General Todd Blanche tried to deploy. Blanche repeatedly pointed to the 2011 Keep Siegel versus Vilsack settlement, a landmark case where the Obama administration established a $760 million compensation fund for Native American farmers who faced systemic discrimination by the USDA as a historical precedent for his own action. But Van Hollen instantly tore down the comparison, exposing a massive structural distinction. Keep Siegel was a class-action lawsuit heavily litigated over a decade and formally signed off on by an independent federal judge, ensuring rigorous judicial oversight. Blanche's fund, by contrast, bypassed the courts entirely, emerging directly from a private settlement agreement between the executive branch and the president to resolve an IRS tax leak lawsuit. By noting that a judge never reviewed or authorized this $1.8 billion account, Van Hollen spotlighted a profound constitutional gap. In congressional oversight, bypassing judicial confirmation removes the traditional guardrails against executive overreach, turning what should be a transparent legal remedy into an insulated, self-directed program run entirely by handpicked political appointees. The tension turned deeply personal when the focus shifted to the explosive allegations regarding how the fund's anticipated payouts are already being perceived outside Washington. Van Hollen brought forward a disturbing report of a pardoned individual accused of child molestation who allegedly attempted to buy a victim's silence by promising future payouts from the weaponization fund. Blanche's visceral reaction, flatly accusing a sitting United States senator of lying on the record, shattered the traditional decorum of a Senate hearing room. Van Hollen's sharp, immediate counterattack, "Don't ever do that again," established a clear boundary against executive defiance. In the theater of congressional testimony, an agency head calling a lawmaker a liar backfires unless backed by ironclad evidence. By standing his ground and clarifying that he was reporting the actual, documented statements of the accused individual, Van Hollen drove home a broader, more systemic point. When leadership telegraphs that a massive, vaguely regulated multi-billion-dollar fund is available to protect political allies, it creates immediate moral hazard, signaling to bad actors that public tax dollars can be treated as a private legal safety net. This battle over accountability extended directly to the legacy of the Jeffrey Epstein sex trafficking investigation. Van Hollen zeroed in on a fundamental contradiction in the department's public posture. Blanche insisted that the DOJ cares deeply about victims and actively meets with their legal counsel, even directly contradicting Van Hollen's data by claiming he had met with survivors himself. Yet, the representative organizations for a prominent group of survivors currently gathered in New York City maintained they had been entirely shut out of face-to-face dialogues with the acting Attorney General. Van Hollen used this disconnect to force Blanche into a corner on a definitive policy position, demanding a clear commitment that the Justice Department would not recommend presidential clemency for Ghislaine Maxwell. While Blanche gave a definitive yes regarding Maxwell, his immediate pushback that tens of thousands of other names exist in the broader files left an uneasy ambiguity. For an oversight committee, a partial commitment on a single high-profile target does not substitute for a systemic, thorough pursuit of justice across an entire trafficking network. Ultimately, this hearing did more than expose a fractured budget process. It highlighted a deep systemic crisis at the highest levels of federal law enforcement. It proved that modern congressional oversight must function as a relentless, precise check against the erosion of institutional norms. Van Hollen used his remaining moments to draw a definitive line in the sand, explicitly reminding the nation's top law enforcement official of the criminal penalties for misleading Congress, a stark reminder that the power of legislative oversight outlasts any single administration. But what do you think? Was Acting Attorney General Blanche right to push back against these intense hypothetical scenarios, or does a $1.8 billion fund created without judicial approval invite systemic corruption and abuse? Leave your thoughts in the comments below. To support our mission of breaking down these critical oversight archives and holding powerful institutions accountable, make sure to like this video and subscribe to the channel right now. Thank you for watching.